My name is Barry Nicholsberg. Joining me today is Mark Williams. My title is Chief Development Officer for Estate and Gift Planning. Mark happens to be a trust and estates attorney who's also on staff as a Senior Associate Director. And a third person on staff who's with us today co-producing is Natasha Roberts. And I thank her ever so much, not only for all she's doing today, but for the graphics that you see. Mark and I can usually put the words together, but they don't necessarily look as nice until Natasha gets a hold of them. You may be wondering why we asked you here today, and that would be a very good question. At least 50% of people over the age of 65 don't have wills, let alone trusts. And there is this mistaken thought out there that trusts are just for rich people, and everyone else has a different definition of what rich means. And I hope by the time we finish today, that regardless of how you used to feel about wills and trusts, that you'll realize that they play a very important role, and they play a very important role for people of all ages. Unfortunately, none of us knows when we're next, and especially with coronavirus. So I find this very important information, and I just hope it's helpful to you. It's whether or not you support the Carter Center, we really do want this information to be helpful directly to you. That said, we hope you do support the Carter Center, and if you do, thank you so much. And we appreciate your trust. The Carter Center thrives, doesn't survive, it thrives because of you. And we have some very exciting things happening at the Carter Center today. We're not here to talk about those. We're really here to talk about what you can do with trusts to make sure that your vision of the future, those you care about, those, whether they're people or pets or charitable organizations, are taken care of as you see fit. With that, we have a disclaimer, of course. And I'm going to ask Mark to handle the disclaimer because he is the attorney.
So let's give this a whirl. The information contained in this presentation of these materials are for educational purposes only. No, I promise I won't do the fast talk radio voice. What I do want to add, in addition to what you see on the screen, is just simply that there are very, very many different kinds of trusts out there. We won't be able to cover all of those today, but what we are trying to do is to give you an opportunity to learn a bit more about the basic types of trusts that are out there, get comfortable with some of the vocabulary so that when you're ready, when you decide that you're ready to go forward and maybe speak with an attorney, you won't just walk in blind. You'll have some idea of what kinds of things you can expect and how they might already apply to your situation. So that was one of the main goals that we had. Also wanted to make sure that, again, as Barry mentioned, we talked to you about the importance of a trust with respect to your estate plan. Again, they're not just for the wealthy. As you'll see as we go forward today, virtually every estate plan should include a trust, and look forward to sharing a little bit more about that with you. So we'll cover trust basics, and we'll talk a little bit more about when you create a trust with your will or while you're still living. And we'll also talk about a very important distinction between a trust that you can revoke or take back and a trust that cannot be revoked. We'll look then at the importance of, again, trusts in estate plans, and we'll follow up with some charitable options. So as we get started, I just wanted to take an opportunity to talk to you a little bit more about just what exactly is a trust. So it may be helpful to think of the trust as sort of like a safe or a vault where you can put property. Now, it's not a physical safe or a vault. It's sort of a legal fiction is one of the fun words we get to use. But suffice to say, you can put property, money, stocks, real estate into your trust, and it will protect those things for you and for your loved ones. And because of that protection, because of the flexibility that's there, the planning opportunities, trusts are simply one of the best estate planning tools out there. So one important thing to think about as you're looking into the trust from the beginning is this really important part. That's that when you give something to the trust, it's not your property anymore. The trust owns it. So there's a separation of legal ownership, and that's very, very important, probably a key concept to the trust. So another very important thing to remember, a lot of people would be interested in this because trusts are often sold as being a tool to sort of avoid probate altogether. And that's because they don't require any court supervision. They don't require any kind of approval to do the things that you've said that you have to do. So that is something that most people look for when they're setting up a trust. And Barry, I'd like to ask if you would talk to us about some of the trust basics that are out there that are so important.
Absolutely, Mark. The first thing is that every state has different laws concerning trusts, how they are established and how they are managed. Most of those laws are, I'll call it boilerplate, but there's some variation from state to state. So if you are in California, it's going to be a little bit different than if you're living in Oregon or Maine or wherever you happen to be. So it is very important that when you decide that, yes, this is something that you want to look into, that you find someone in the state who specializes in this. And they're called trust and estates attorneys. A trust is a great way for you to manage property and stock and bonds. As Mark mentioned, it doesn't belong to you anymore. It belongs to the trust, but you get to pick the trustees, and you may be the sole trustee. Yes, I put my house in the trust. The trust now owns it. The trust can sell it. I'm the sole trustee, so I continue to manage my property. I can buy and sell stock through the trust. I can do anything I would normally do, but the trust owns it. Thus, it is protected, not just from probate, but possibly from creditors as well. We'll talk about that a little bit more soon. You can name multiple trustees if you wish. Oftentimes, in these trusts, you are the sole trustee until such time as you either pass or become incapacitated. And it's that last point that I encourage you to really consider, because we've known so many people who really never thought about becoming incapacitated. And it happens. It's sad, but it happens. And to have fallback trustees named, there may be 2 or 3 or 4. It may be a spouse, a child, a grandchild. It may be your attorney or several attorneys. But how the trust is managed is really up to you, completely up to you. With that, I'd like to turn it back to Mark. Let's continue.
So something that you need to think about when you're looking into a trust and choosing a trustee, as Barry mentioned, you want to think about having people who can be there for the long haul. So yes, this could be you, and you could manage this trust for as long as you live, and that's absolutely fine. But oftentimes it makes sense to think about people who will serve as backup trustees, and if you name other people to serve with you, it's a good idea to think about naming people who are younger than you. So there's some sort of longevity to the trust management. For those who are thinking about setting up a trust for a very long time, it may benefit your grandchildren or great-grandchildren. It really can be helpful to think about actually having an institutional or a corporate type of trustee, like a bank or a trust company or even a charity, to manage the trust for a long period of time. Again, this helps, generally speaking, with knowledge of what was going on when the trust was originally created and having continuity all the way through. So that's very important. But more important is the fact that you must have someone who you know you can trust that will carry out your wishes. Now, this is very, very important in the case where the trust provides some sort of discretion to the trustee, especially if you can give out money or property to people that are beneficiaries, and you can do it in uneven amounts. Say, for example, you've got, mom's favorite diamond ring, and your two daughters both really want it, that could, if the trustee gives it to one or the other, lead to some issues. And so that person, whoever they are, or those persons, will need to be comfortable managing those kinds of conflicts and navigating them while maintaining your instructions. But they also need to be very comfortable with accounting and legal process. So all of those things are very important aspects of what a trustee does. Now, as Barry mentioned, if you're talking about naming multiple trustees, it's very important to think about naming an odd number. In fact, if you do name more than one, please don't set an even number, because if there's ever a tie, you'll have to go to court, and that does not end cheaply or quickly. So, and you just never know what a judge is going to decide. So it's better to just go ahead and prevent that from happening right out of the gate. But it's also very, very important to think about compensation for the trustee. Now, if this is you, obviously you're probably not going to want to pay yourself, but it is possible. And if you're naming someone else, you need to think about the amount of work that they're going to be putting in to managing this trust property for the people who are the beneficiaries, which could even be you. So make sure that you say this. If you don't set anything out, there's usually a state law or rule somewhere that says the trustee gets a percentage of the trust assets for managing that property on an annual basis. It's not just a one-time fee. So that's very important. One of the other things that you need to be thinking about with trustees is the powers you're going to give them. So they have to have sufficient power to manage the property for the benefit of those people who are entitled to the property, the beneficiaries. And so generally there are a default list of of rules provided, powers provided under state law. And those are usually pretty expansive. You can increase those or decrease those, but every single time the trustee must have the power to invest that trust property, to sell it, pick up new investments. It's a really good idea to allow the trustee the ability to enter contracts, to borrow, or even to loan money at the trust property. That's a very big, helpful thing. But something else to think about is whether or not you might even want your trustee to be able to engage in a lawsuit. Not to be, here the lawyer talking about lawsuits again, but say, for example, you were defrauded in a securities case, you would want your trustee who's holding that property to be able to go forward and handle that claim for you. So again, it's really important to be thinking about these kinds of things. But if you're going to give discretion for a trustee to make payments or withhold payments or to give different amounts, you really, really need to think carefully about that and try to be as specific as possible. So again, multiple trustee situation, one of the great things you can do is divide up the responsibilities and the powers. So you may have a trustee that only is able to handle investments and another that's only able to handle the accounting and the preparation of tax returns. So you get a lot of flexibility there. It's something that can be very helpful in planning. But another very important part for trustees is this concept of what do you do if you ever have to replace or remove a trustee? If this is you and, God willing, you're out here, you're managing your trust property for, the time until you reach 100 years old, you may not want to keep doing it at that point. And so you want to have the people already named in the process in place for this. So that's why we talk about naming multiple backup trustees or successor trustees. And again, if there are situations where the beneficiaries are unhappy with the person who's managing the trust property, you want to provide them an avenue for being able to remove the trustee and really be clear about how they can do that. So again, these are all very important parts to consider. You need to make sure that you do this in advance. And with that, I'd actually like to go and start talking about trust beneficiaries and ask Barry if you would mind taking us forward on that.
Happy to, Mark. So the trust beneficiary is very simple. It may be your spouse, it may be your children, it could be grandchildren, it could even be your pets. Helmsley, I can't think of her name right now.
Leona Helmsley.
Who?
Leona Helmsley.
Yes, Leona, exactly right. Leona Helmsley left millions of dollars to her cats. It's a possibility, and it can be done through a trust. You could also name classes of people. So you may not even have grandchildren, but you could say, in the event that I do, this is what I would like the grandchildren to have. Or you have two now, but you may have more later. And so you take you have a position within the trust for them to be possible beneficiaries. Also, just ever so briefly, your trust can actually earn money. You could put rental property into it. You could put all kinds of, it's not just your house, it could be a vacation home, it could be all kinds of things that would make it possible for you to reduce your estate and manage your property as carefully as you would like, and make sure that others will manage that property in the event that you can't. So with that, let me move on. Yeah, I had to put glasses on for this. Sorry, folks. They have beneficiaries, very important point, have the right to trust assets. Now, they may not have the right to trust assets while you're alive, but they may, depending upon, again, how it's set up. And they also, I've known ever so many trust people who are beneficiaries of trusts who decide that they're going to sue the trustee or trustees because they don't like how the assets have been managed. And this can be a real problem. And it's something you really do need to be aware of in the event that you want to be planning for the future. You can include very detailed instructions on the management of the trust assets. That's what's key there. So moving on to the next slide, as I turn the page, a trust can own, as I said before, almost any kind of property, and it's almost limitless, and including a business. And this is really key, because if you ever plan to sell a business and you don't have, let's say you started the business, and so you had nothing, you started it in your basement or your garage, and it has now developed, it's worth $30 million. Before you have someone who would like to buy it, before you ever even talk to people about buying it, you can put that business into a trust. And then as you are the trustee, then you can go and sell it. But you personally are not going to be paying the capital gains tax between the nothing, the zero that you started with when you started the business, and the $30 million that you sell it for. And if that's 15%, you're talking $4.5 million. At 20%, you're talking $6 million. It's real money. So there are ways to make sure that that money stays with you or with your family. And one of those very important ways is through a trust. Mark, why don't you take it from here?
Very good. One thing I would just add quickly before we move on with that point, particularly for the business owners out there, we mentioned the potential for some of the beneficiaries to potentially get upset about how the trust property is managed and potentially going to court over that. And I'll say sometimes that can be especially difficult for business owners. Say, for example, you have, 4 children, 2 are working in the business and 2 are not. The 2 who are not may get concerned that having a lot of the stock or a lot of the trust tied up in just the business itself may lead to sort of less quality gains and diversification. And so that's one thing to keep in mind. You definitely need to be thinking about that and planning for that as a business owner. But I'll move on and just say that, now that we've talked a bit about the important people, the parties to a trust, and how a trust can own and manage property, we need to talk about why people would do this. And I mentioned before, some people think about a trust and they're often sort of sold as a tool to avoid probate. And while that's true, it's probably not the most important reason. The legal protection that a trust offers is probably the #1 reason why people would think about having a trust. So we used to talk with people like physicians, surgeons, even had a client once who was in an explosives demolition field, high-risk occupations where people might try to come after them for their assets, their property. It makes sense there, but it makes sense really for everyone. If you're thinking ahead and doing this kind of planning, why not take advantage of the legal protection that's out there for you, for your loved ones, for the inheritances that you want to leave behind? Trusts allow you to do that. Not only that, they allow you to be very, very clear and control the types of funds that you'll give out or property when that happens. Also, you can do some really, really great things to incentivize your children or your loved ones to go out and to do things. For example, you could say, upon reaching the age of 18, my child could have a distribution from the trust to attend college or a technical school, or to start a business, or you could even go another step and set a standard. So one of my favorites was always, you basically allow distributions from a trust to allow the person receiving them to maintain the standard of living to which they've grown accustomed. That's a pretty fun one. But more generally, you see the standard used to pay for medical expenses, healthcare, education, and those are really important things to think about too. So one of the other things that you need to think about going in while setting up your trust is the time at which it ends. Now, there are a few places out there like Alaska and South Dakota where you can have a trust that goes on forever. Those are called dynasty trusts. But that is more the exception than the rule, so you won't find it everywhere. And so it's important to think about how the trust will ultimately end. You need to have that process in place from the beginning. So as you think about all this that we're talking about, know again, there are a lot of different trust types we're not covering, and every trust has its advantages and its disadvantages, and really often the one that you choose is going to be based on how much control you have to have or want to have over trust property and business, and the type of legal protection that you really want. So keep that in mind as we move forward. We're going to take a quick look at the 2 times you can create a will or a trust, excuse me, and also the 2 really important distinctions between trusts that you create while living. So with that, Barry, may I send it back to you?
So you can create a will, you can create a trust at pretty much any time. So you could sit down today and create a trust and a will simultaneously. A good idea. You may already have a will that you feel is up to date and current, but now you would like to add a trust. Or you could have a trust established on the day you pass. In your will, it says these assets will be put into a trust. This will be the trustee. These will be the trust beneficiaries, especially if you have young children or very young grandchildren. There's no way they're going to manage money on your behalf or take over a business on your behalf because they're just too young. But you can make those provisions in your will to have the trust established upon your passing and have all of these assets put into the trust. And then, of course, explain how you want that trust managed. And so that your vision of the future, your hope for the future, for whether it's children or Leona Helmsley with pets or lots of people are naming charities, including the Carter Center. And I'm not pitching the Carter Center here, although I am, but I'm just saying you can leave to charity. You can set that up. You can put these trusts and you can write your wills in such a way that your vision, your hopes and expectations will be met. But I cannot emphasize enough that age has nothing to do with this. If you're 25 years old or 85 years old, the documents you need are the same. And without them, you're risking way too much. And we have known so many people whose estates, very famous, exceedingly wealthy people, who passed without a will, without any trusts in place, and the lawyers have had a field day, just making money like there's no tomorrow. But the beneficiaries are out there fighting about it. It's totally unnecessary, and please consider it. You can create the trust during your lifetime, which means it could be revocable or irrevocable. A revocable trust is one in which you could change your mind at any time. It's extremely flexible. You can put assets in, take assets out. You can actually close down the trust if you wanted to. It's as flexible as you want it to be. If you have a revocable trust on the day you pass, your revocable trust becomes irrevocable, which means no more changes. And that's the key. That's the difference between the two. And where a revocable trust can buy and sell, an irrevocable trust has far more restrictions to it, and for good reason. Now, you can actually continue a revocable trust, but you're going to need help in figuring out how to do that after you pass. Whether or not your revocable trust becomes an irrevocable trust, which funds a revocable trust. I can understand why you may be very confused by everything you've heard in the past 27 minutes. If you are confused, let me simply say that Mark and I will be around and easy to reach either by email or phone. We'll go through that a little bit later in this presentation, but please don't hesitate to call or write and say, well, could you just explain this one more time? And we're happy to do that at any time. With that, Mark, let me turn it over to you.
Fantastic. You know, we talked about this idea of legal protection and that it can vary with different types of trusts. And I do want to make sure to emphasize that with a revocable trust, because you can always take it back, the property is sort of still viewed in some ways as being yours. And so if something happened and someone tried to go after that property, it's more possible with a revocable trust. So it's something to think about in terms of that legal protection aspect that's so important. But so is you know, like, why would you just want to do this anyway? And who would set up this kind of trust? And again, if you're a business owner or an investor and you really want to maintain that control over your investments and how the business is run, this is going to be key for you to hold it in this kind of a trust. And again, flexibility will be something that's guiding you all along. And that's a little bit more important than this legal protection. But another really, really important part is this idea that if you do have a revocable trust, the property that passes on to your loved ones after the fact receives a step up in basis. And that's a very, very important concept. It's a great way to transfer wealth. And I'll explain it this way. So say you've got this really great Uncle Warren Buffett out in Omaha, and he loves you very, very much. He decides that he's going to give you $1 million of Berkshire Hathaway stock when he passes away. Now, the great thing about that is, as you inherit them when he passes away, let's say the stock is worth, again, $1 million. It doesn't matter how much he paid for it or invested. The fact is you could turn around and walk away and sell it, take the whole $1 million and put it in your pocket. But let's say Uncle Warren loved you so much that he was going to give you this stock one day before he passed away. Well, that leaves a problem. See, as you take the ownership of that stock, basically you owe taxes on whatever the profit is that Uncle Warren built up over the years of his investment. So let's say it was $100,000 he paid originally, and now it's worth $1 million. You'll owe taxes on $900,000. So I don't know about you guys, but I'd rather have the whole $1 million than pay something in taxes. And so that's one way you can do it with a revocable trust. Now, Irrevocable trusts, again, the opposite side of the coin. Barry mentioned there's virtually no flexibility to these whatsoever. You need to really, really have your plans together before you actually put pen to paper for these. And that's because making a change either to who gets what or to the people who can actually get anything, or even just changing a trustee can be really, really complicated. And even if you have everyone in agreement, you still may have to go to court, probably will have to go to court, and you just never know how that's going to come out. It may not be able to be changed at all. So it's very important to have all of this figured out before you go in. And we go back to this idea of control because it really does make a lot of the difference with respect to the different trust types. If you are a person who's creating this trust, you're not going to be able to maintain full control over a business or rental property. Again, the reason for that is you get this much greater legal protection. It doesn't look as if you're able to withdraw the property or to keep sort of manipulating it as you wish. And that's why you get that extra legal protection. You can't just take the property back or exchange it for something else you have. And because of this, again, tax issues are so very important, and they often drive a lot of this. So again, if you've just got to have that control, you're going to maintain that kind of close grip over a business or something, you have to understand that that's going to come with some additional tax consequences. Doesn't mean you can't use the irrevocable trust, but it does mean that you're going to potentially have unintended taxes that come due. So one of the things, again, as we talked about this with the legal protection, the great thing is because it's not your property anymore, no one can force the trust to give it up. So say, for example, again, I mentioned, you're a surgeon and someone's injured, they sue you and they have a judgment against you, that they can't actually make the trust give them any of the property that you put in there for yourself or your loved ones. So it's very helpful. And the other thing, going back to taxes just one more time, is this idea that having things in an irrevocable trust means they're not a part of your estate, so they generally won't be having any kind of taxes due on them. But on the other side of that, you don't get the benefit of the step-up basis. So that's something else to keep in mind. So again, this is often a concern for people who are thinking they're going to owe estate taxes. Those thresholds right now are about $11.5 million for individuals, $23 million for a married couple. So you can see where obviously people with great wealth who are going to hit those caps might be thinking about some of this stuff. So again, who chooses this kind of trust? Say you're a business owner, an investor, you have this property that's spinning off money. You want to keep taking the money from that as an employee or something. You could totally do that, but you really ultimately want this property to go to your loved ones. That's what this kind of trust is for. Again, legal protection is something that is going to be of paramount importance for you, your loved ones, and the property that you're trying to give them. And there are some tax issues that will be driving your decisions with these kinds of trusts as well. So with that, I'm actually going to ask Barry. Will you come back and talk to us about how trusts can help with individuals for estate planning and other purposes?
First of all, it can protect you from creditors. Very important. It will also protect inheritance. It's called a spendthrift trust, which you see up on the screen. I knew a 21-year-old who inherited $1 million, and within 10 months, the $1 million was completely gone because she had no concept of saving, or it just disappeared. It was probably a very fun 10 months, but for those of us on the outside who are watching and shaking our heads helplessly, you can set something up in a trust to make sure that you are not giving too much to someone who really could not handle it at that time. You can also make sure that you can make gifts to charity through the trust, and obviously this can make sure that you are protecting loved ones from paying excess taxes. And tax base, it changes. Tax laws change all the time. and we just need to be prepared. Just because the tax law change doesn't mean your trust changes. So you really, we advise people every 5 years to go back and look at their wills. You should really be looking at your trusts every year. You should go back and look at it if you have set up a revocable trust or even an irrevocable trust, to go back and look at it and make sure that it's still current and it's just the way you want it to be. If it is not fully up to date, you can put yourself or your loved ones at some risk. And so I would encourage you to make sure that that gets done. Moving on, you get to name guardians in your will. The guardians are not mentioned in a trust. So people often ask, well, why do I need a will if I've already got the trust? If there are children involved, or even pets. If there's a business involved that you want to make sure is passed on to children or grandchildren in the future, but not right now, then your will can specify how that trust will operate in between. And there is a big difference between a trustee and a guardian. And please, please make sure they are not the same person, no matter how close you are. Make sure, because if you're the trustee and have access to all this wealth and you're also someone's guardian, you may not be spending the money in the child's or children's best interest. But having at least two people, one balancing the other and making sure that property is kept where it's supposed to be kept, will be very helpful. I would guarantee it. Let's talk about how a trust works specifically with your will. For business owners, as I said, if you put the business into the trust, it allows, there are any number of advantages to it. And that's something that you just want to, especially if you're ever planning to sell it. But even if you're not planning to sell it, you'd really like the children, you own a restaurant, or you own a car dealership, or whatever it is. If you want others in your family to continue, it's best to make sure that it's in a trust that will continue until they are of certain age and ability. It is, if you would like information about wills, Mark and I have already conducted a webinar on wills a couple of months ago. And since you have this material, not just on the screen, but you should have it in a PowerPoint or a PDF, that these are clickable links. If you want to go back and look at previous webinars where it says click here, that's one of them. That will take you right to the webinar we did on wills. There's another one coming up in just a few minutes. We'll talk about that as well. I will also say that after our webinar last week, same one as today, someone contacted us, actually two people contacted us and said the links aren't working. We've done everything we know how to make sure those links are working. If you have a problem with them, please, please let us know. And a worst case scenario is we will send you directly the file that you need to have the PowerPoint in front of you. The information we're dealing with is certainly not proprietary.
That's actually a great reason to email. If you have any issues with accessing the material, we'll send you the direct links like Barry said, but we could also send you out copies of the PowerPoints that we use during those presentations too. So silver lining, if you hit some technical difficulties, please do reach out. We promise to get you the good stuff.
Mark? you're on a roll. Go for it.
All right, so we're here talking about estate plans, and a lot of people, they hear that word and they think, okay, if I've got a will, I'm covered. Well, the truth is a will is a very important starting point for an estate plan, but it is not the entire estate plan. There are many other documents that you need, but probably the next most important documents are going to be powers of attorney. So powers of attorney simply are contracts that you set up with another person who basically, should something happen to you, you're injured, you are sick, and you can't take care of your own affairs, this person has been given the authority to step in and manage your affairs for you. Now, there are two important types, a general power of attorney and a financial power of attorney. Obviously, the financial power of attorney, as it sounds like, is going to handle a bit more of the banking or investment kinds of things that you'll do. It's important to have both, but if you have a trust, you really, really must be sure that your powers of attorney work and actually speak to the trust that's out there. Even if you're a beneficiary of a trust, you still need to possibly have this in place. Again, if all of your property is in a trust and something happens to you, you can't take care of yourself, there's no power of attorney in place, there aren't any successor trustees in place, that's going to be a very bad situation. You're going to have to go to court and spend a lot of money to have a legal guardian appointed, and you're going to have another trustee appointed. And the problem is, during all of this, your loved ones are going to have ongoing needs, just basic financial needs for food and their rent or housing costs. And you don't want to delay them, make them have to go into credit cards. So you've got to think about this all in advance. And again, without this harmony, you just will be setting them up for unnecessary expense and pain in court. So please do your best to take care of that. And if you're interested in learning more about the other documents that are part of a good estate plan, I'd encourage you to check out this webinar that we did. It's everything except wills. So as that sounds like, we'll cover basically the powers of attorney, all kinds of other great documents that are the full set of what you'll need to have a good estate plan. And this will really take care of your loved ones. So please do consider going ahead and putting that together. And also please do consider your loved ones as you're looking at all of this. So Barry, do you mind picking it up with a little bit of additional discussion around charitable trust planning?
Well, now we talk about a different kind of trust altogether. A charitable remainder trust will pay you, and then for our 20 years or a lifetime, depending upon how it's established, and then the beneficiary becomes the charity you named in the beginning, which then, so let me make this easy. You have $100,000 you would like to invest. You really want to help the Carter Center. You really would like some income as well. And so you can create a charitable remainder, two kinds. There's a charitable remainder annuity trust. You fund it one time and one time only. And it's a guaranteed payout year after year. There are some formulas that go into it, but you get paid year after year. And whatever is left when you pass belongs to the charity. If there's nothing left, so there's nothing left. That's just the way it is. There's also a charitable remainder unitrust. Now, a unitrust can be funded over and over again. So yes, you've got $100,000 that you just inherited. Let's put that in the trust. And oh, I'm selling this business. I'll put that money in the trust. And I've got antiques and I've sold a bunch of those and I made some money. I'll put that in the trust. And so your income, it can continue to grow from that year after year as you put more into it, or because it's invested so well that it's coming up with more money. A charitable remainder annuity trust pays you the exact same amount year after year forever. Well, not forever, but essentially. But a charitable remainder unit trust, it fluctuates. And depending upon How you feel about risk management will determine whether or not you want, and now here comes the terms, because charitable remainder annuity trust always goes by its initials, CRAT, where a charitable remainder unit trust goes by CRUT. Now, just to make things more difficult for you, if everything is based upon something happening to fund the trust, you've created the trust, there's a charitable remainder unit trust that's on paper only, it hasn't been funded, but it will be funded the moment the business is sold or the moment someone passes or whatever. That's called a flip CRUT in this case. It has to have some event, whatever that event is, that funds the trust. There's another kind of trust out there. I just want to make sure you have some sense of it. If you create a trust that's guaranteed to pay you the same amount every year, and your trust doesn't make that much, let's say, we've hit a terrible slump, and for 3 years, the trust just simply has not made enough to pay you what it was expected to pay you. There's a kind of trust that can do a makeup in the future. So years later, the trust is doing quite well and can go back and pay you what it should have paid you during those lean years. And I'm not going to get into all the letters of the alphabet, but if somebody says NIMCRUT, what they're really talking about is making sure that this makeup in the future can happen for you. Mark, you want to take it?
Certainly. So, as we've talked about these different alphabet soup charitable remainder trusts, hopefully we haven't confused you much, but if we have, please don't hesitate to reach out to us. We'd be happy to walk through this a little more slowly and more detail. But one of the things I really want to drive home about these is that they are incredibly highly regulated by the IRS. I mean, every I and every T have to be exactly the way they say. Otherwise, you run the risk of not having qualification as a tax-exempt charity or a tax-exempt trust, excuse me, and that will cause the loss of your deduction, potential penalties and interest. So it's important to do these right. And some of that may mean that, if you've got some people who are particularly for younger beneficiaries, say you're going to set this up for your children or your grandchildren, it may be necessary to have this pay out for a number of years rather than for a lifetime, just so that it qualifies. But just wanted to make sure you understand there's a little wrinkle with that, again, because of these IRS rules. And obviously by now you probably understand that these things are technical and complicated. So very, very important to have an estate planning attorney help you with this. Not just for the setup, because there are ongoing requirements every year in terms of filing taxes and additional legal compliance, accounting. All of this stuff can be costly. So make sure you think about that as you're considering setting up one of these trusts. But if you're thinking about naming the Carter Center as a beneficiary or a sole beneficiary, if you name the center as the majority beneficiary or sole beneficiary, we do provide these ongoing trust services at a discounted rate. So if you're interested in learning more about that, please let us know. One of the other things that we really try to help people out with is the changes in the laws that occur, and they seem to be happening more frequently now around taxes. The beginning of this year, January 1, a new law, the Secure Act, this is Setting Every Community Up for Retirement Enhancement Act, made sweeping changes to virtually every single kind of retirement account out there. And so if you were planning to leave your loved ones, your children, your pets, your IRA, know now that there are some new rules in place that are going to mean that there are even more taxes due on those inherited IRA funds. Now, there are some really great options for charitable trust planning that you can use to avoid some of those high taxes. And if you have some interest in that, please click the link that we've got here on this page. It'll take you to the entire webinar discussing the Secure Act and the changes in the law and how you can use some of these charitable instruments, again, to avoid some of those unnecessary tax burdens that your loved ones might face. So One of the things as we get an opportunity to talk with folks, we like to try to talk strategy, and being strategic with these changes in the laws is just more important than ever. So if, again, you're thinking about setting up one of these trusts for your children, you really want to make sure you have it customized for them. You don't want them to be in their final years of working, making more money probably than they have before, and as a result, paying more taxes than they had before. If they start getting income from this trust at that point, it's going to be taxed at the highest rates. By being careful and selecting another time period after they've retired, you're going to be able to reduce the taxes that they would have to pay on it. So that's what we mean by being strategic and planning around these things. So if we can assist with any of that, certainly it's our privilege and our pleasure. And with that, I'm actually going to ask Barry to pick it back up for the discussion of charitable lead trusts.
And I'm going to do this fairly quickly because we do want to end right at the hour, and that's about 9 minutes from now, and we certainly want to leave time for Q&A. So a charitable lead trust is sort of the opposite from the CRAT or the CRUT that I talked about before. The charitable lead, but there are the same thing: charitable lead annuity trust, charitable lead unit trust. One is funded one time, one is funded multiple times. This is where the charity that you name, perhaps the Carter Center, is the beneficiary for 20 years. So we'll just say you had $1 million, you created this trust with $1 million, and the Carter Center will earn 5% of that $1 million, or $50,000 a year, for 20 years. At the end of 20 years, that trust names other beneficiaries. We'll say you had grandchildren who were young at the time, now they're in their mid-20s. You feel that they really could handle this at that point. And so you set up this charitable lead trust. The $1 million that funded this lead trust and gave you an extraordinary tax deduction. Now these two children inherit $500,000 apiece. That money, which actually set up the trust, no tax. Let's just say that the trust was very well invested and had tripled in value. So it was really worth $3 million, even though it continued to pay out to the Carter Center for 20 years. 20 years goes by, the $1 million has turned into $3 million. The first $1 million goes to the kids tax-free. Then there's 2 million more. Each of them get $1 million. What kind of tax are they going to pay then? They will pay a tax equal to the adjusted federal rate on the day that this lead trust was established. Today, the 25th, if I recall, of August of 2020, the adjusted federal rate is 0.4%. Instead of 40% of estate tax, they'll pay 0.4% tax, and that's it. Now, we're really running out of time. Mark, I'd like you to finish up, let folks know kind of how to find us, and then grab a couple questions before we close out.
Absolutely. Again, just if you're interested, you have a trust or you're setting one up, you want to do some charitable estate planning, super easy to do with the trust. We'd be happy to talk to you about that in greater detail. And we'd also be happy to work with you and your advisors to discuss some more of these details. Now, one of the other things to think in mind, to think about again, as you're looking at these, just know that sample language can be helpful, may not be all you need, but hopefully it'll save you a little time and money. So we're here for that. Always happy again to work with you all. Just let us know. You can reach us by clicking on our cards. If you do that, it'll send an email to Barry or to me. Also, feel free to use the telephone numbers that you see there. Even though we're not in the office, we are answering our phones. And with that, we'll go ahead and start the Q&A. And I'll say that I've actually got a question here that asks, what are the issues of including investment property in another state? Does this complicate title transfer to trustees or beneficiaries? And that's a really great question. So one of the things that I would say with these kinds of trust property where it's in a different state, it may complicate things to the extent that if it's very far away, say it's in a foreign country or something like that, you may need to have a foreign trustee who is able to manage that property for you. But in terms of titling the property, in terms of moving them into the trust, that shouldn't really be any more difficult than property you have in state or in country. So again, very important to work with an estate planning attorney, particularly if you're in that international category. There are some really important rules to be aware of there. But do also know that what you've asked is totally possible. If you have some more detailed questions you'd like to talk about, certainly be able to help you out with some additional detail. I do have an additional question here too, that asks, can all distribution decisions, be left to the trustee to decide? So that is basically called a discretionary interest. Yes, it is possible. We talked about some of the dangers of having something being fully discretionary without some sort of kind of standard or guiding details for that. So it's helpful actually from a legal protection standpoint if it is a fully discretionary interest, because say someone sued a beneficiary and they were able to come and claim money from those folks, they could never go to the trustee and say, you must pay me X from the trust, because the trustee always has the discretion to say, I don't have to pay that person anything. So again, there are trade-offs with respect to that strategy. I would definitely be concerned about thinking through that. So if you've got some additional questions on that point, again, please do reach out to us. We'd be happy to talk to you about that further. Let's see, Barry, do you see any additional questions?
I do not at this time, no. So what I'd like to do is invite you, please, if you have questions for us later today, tomorrow, a week from tomorrow, a year from tomorrow, a decade from tomorrow, whatever, don't hesitate. Mark said we're not in our office. That's because of COVID-19. We're all of the Carter Center, we're all working from our homes, but we are absolutely accessible. If you call the phone numbers on our cards, the phone will just transfer to our cell phones. So please do not hesitate whenever we can be of help to you. And we regularly hear from people who say, well, could you at least, could you speak with my attorney? And generally, we are speaking with people, oh, he's my best friend, he was my great friend from high school, he's an attorney and he's helping me write my will or prepare my trust. Problem is he's not a trust and estates attorney, and so this particular attorney is not necessarily up to speed, but he's the person you really trust. And so yes, of course, we will chat with that individual and make sure that he or she is up to date so that you can get the best possible final product. On September 17th at 2 p.m. and on September 21st at 5 p.m., Mark and I will be back with another webinar series. We'll just be repeating it. And that one is on insurance and annuities. So whether it's life insurance, commercial annuities, charitable annuities, we're going to cover that ground pretty carefully. And we certainly invite you to join us again. We thank you ever so much for spending the past hour with us. And with that, I will say, please, in these bizarre times that we are currently living in, please be safe, stay healthy, and Godspeed. Bye-bye.